My name is Thomas Burrell, and I am the president of the Black Farmers and Agriculturalists Association, Incorporated. You are about to listen to a short video regarding two decisions and or actions that this organization has taken in the last several days. On our last update, we were explaining an order that was signed by the Honorable Judge Reggie B. Walton as regards to terminating the tolling of the statute of limitation. You will recall Judge Walton entered that order in April of 2015, and that June the 8th of 2015 was the cutoff date regarding this termination. We sent out many notices through the mail, the telephone, and even through another video, encouraging our members to become current by the June 8th date. Many individuals complied. However, we are receiving hundreds of calls from individuals who are in two categories. The first category would be members who, for whatever reason, had not renewed their membership dues. They are wanting to know, can they still become current, even though it would be after the June 8th date. The other category is from individuals who are acknowledging that they were never members of this association, but wanted to attempt to become a member of this association. After several conversations with our legal representatives, this association has taken a position that, yes, we will accept membership dues from individuals who were, i.e., late, but they were current members all along, but for whatever reason did not renew their membership by the June the 8th. And we have decided to accept memberships from individuals who were never a member of the association. And the rationale for this, the attorney cited, was the result of what happened in 1999 when Judge Friedman also issued an order in his consent decree and his subsequent 65-page opinion, where in the first lawsuit, Judge Friedman stated that the time period in which a person could become a member or at least a party or a claimant in the Pickford 1 lawsuit was from April the 14th through April the 12th of 1999. He also appointed an attorney who was the mediator for the Pickford lawsuit by the name of Michael K. Lewis. And he gave Mr. Lewis the right to determine whether or not individuals were late in that lawsuit. In its consent decree, the Pickford 1 consent decree, there was a paragraph known as paragraph 5G, and I'm going to read it. It says, a claimant who satisfies the definition of a class in 2A above, but who fails to submit a complete claims package within 180 days of entry of this consent decree may petition the court to permit him to nonetheless participate in the class resolution process provided in paragraphs 9 and 10 below. The 5G paragraph continues by saying, the court shall grant such a petition only where the claimant demonstrates that his failure to submit a timely claim was due to extraordinary circumstances beyond his control. End of that quote. In other words, in 1999, the judge who had jurisdiction over Pickford 1 also set a time limit. And that time limit was from April the 14th of 1999 to October the 12th of 1999. And that any person who joined or tried to become a party to this lawsuit after the October 12th deadline, Attorney Michael Lewis had the authority to determine whether or not those individuals were late. of approximately 26,000 or more of those individuals, he only let in a few hundred. And those other individuals were considered late filers. A little bit of history again. This association then, we filed motions to Judge Freeman's court. He denied our motions between 1999 and 2000, stating that these individuals were late and there was nothing that he could do. The Black Farmers and Agriculturalists Association then went to Congress and asked Congress to pass legislation to allow those late filers in. We know that that happened because in 2008, Congress allowed the second group of black farmers, referred to as INRI, Black Farmers Discrimination Litigation. That was for the individuals who tried to get in 1999, but were denied because they were late. So Pickford 2, or INRI Black Farmers, was for that group of individuals. In other words, let me recap. Those individuals were denied the opportunity to become a part of Pickford 1, and Congress subsequently allowed them in. There was a dilemma there in that, and let me use this illustration. Let's say that there were two individuals, family members. One was Brother A, and Brother A filed late, or didn't file, as it were, until after the judge's deadline, which was October the 12th of 1999. And he was instructed by actually all the lawyers, or heard rather, that all the lawyers who were involved in this case, which were referred to as class counsel, were telling people it's too late for you to get involved. You didn't file before the deadline, which was October the 12th of 1999. But some of those individuals insisted and still attempted to get into the lawsuit. Now, this is very important. Let's say Brother A was one of those individuals, but his other brother, Brother B, says, well, the lawyers are saying it's too late. The judge is saying it's too late. All of my friends and neighbors are saying it's too late. So I'm not going to try to apply because I know I'm late. However, when Congress reopened the lawsuit in 2008, and after President Obama signed legislation, the only group then that was allowed into INRI Black Farmers was the Brother A, or people such as or like Brother A. In other words, of those two family members, both missed the deadline, but one tried to get in and the other one did not. And here again, when Congress subsequently came on board, they said, yeah, we're going to open up the second Black Farmers lawsuit. But guess what Congress said? The only group we're going to let in would be the people who tried to get in even though the door was closed. So the phrase attempt is relevant here. And this is why we're saying, if we then look back at what happened in 1999, those individuals, and let me put it this way, who followed the attorney's instructions, Brother B, and they were telling these individuals it's too late. The attorneys were telling these people it was too late. Brother B says, I'm not going to try. Brother A says, I know they're telling me it's too late. I know the deadline has passed, but I'm going to try to get in anyway. Guess which one of the brothers prevailed in Pickford? In other words, which one of the brothers was allowed to get in the second Black Farmers lawsuit? It was Brother A. So we're saying we have individuals here in 2015 who are similarly situated to Brother A. They're saying, yeah, we missed the June 8th date. We understand that, but we're going to do what the people in 1999 did. We still want to be able to get in because we realize that if indeed we are successful with our Rule 24 motion, the courts may say, yeah, we will allow BFA members to come in, but only those who tried, only those who attempted, and the ones who didn't try, we won't let them in. Now here again, what we are saying, what our attorneys are saying is, to recap, the courts or Congress may take the exact same position. That is to say, they will only reward the people who tried, who attempted to. And if we look back at the very essence of all of these lawsuits, one of the four questions that we all had to answer was, when it comes to USDA, we could only show that we were discriminated against if we tried, if you went to USDA, if you made an effort. You can't say you were discriminated against by an agency because everybody said, well, they won't let black folks have money. Well, it won't do me any good to go down and apply for a loan. I heard they're not making any loans. I heard that they're out of money, so I'm not going to try. Well, here again, we know that one of the components of this very lawsuit is that you must have demonstrated and shown that you constructively or you attempted to apply, whether USDA employees allowed you to fill out the application, whether USDA employees allowed you to come in and talk to them about a loan. They may have said, no, we're out of money. No, we're not making any loans. But you can only have prevailed or would have been able to prevail in these lawsuits if you took the position that, yeah, I tried. I attempted to fill out an application, but they denied me. So, as we have said earlier, after talking to our legal representatives, we have decided to allow a member who was not current by June the 8th to do so, and B, to allow a person who was never a claimant or a member of this association to do so, because we are an advocacy association. We represent our members. We argue. We plead. We stand in the gap. And we do not want a person to say that if you all had allowed me to come in, then the decision that the court has made, I would at least have some document saying that I attempted. So we believe that here again, because of the fact that we are an advocacy group, and right now, the only advocacy group out there advocating for the rights of black farmers, their heirs, ranchers and their heirs, who are trying to become parties to the current lawsuits, which are styled the Hispanic and female farmers and ranchers lawsuit. Now, the second thing that we would like to talk about is what our attorneys have done today as it relates to a group of individuals, particularly African American males, who try to become claimants in the two latter lawsuits, the Hispanic and the female farmers and ranchers lawsuits. And they have been summarily denied by the claims administrator, a company out in Portland, Oregon, known as EPIQ, which is the old claims administrator from the Pickford 1 era, and they were known then as Pullman Douglas. Pullman Douglas then and EPIQ, EPIC now, were appointed by the attorneys, class counsel, to in effect receive documents, among other things, transfer documents back and forth to potential claimants. And as we said, we know that thousands of claimants or submitters, whether they were male or female, who either were filing a claim on behalf of themselves if they were a black male, or filing a claim on behalf of their brother, their father, or uncle. They may have been a female submitter, but they were filing on behalf of a male claimant. And they were denied for no other reason but the fact that they were a male claimant. We believe then that that was a gross violation, particularly of a statute that was passed in 1964, known as the Civil Rights Act of 1964, and particularly Title VI of that act. I'm going to read for you what that act states briefly. Now, the other issue that we would like to talk about briefly is the fact that on this day, June 9th, 2015, our attorneys have filed a lawsuit in the Federal District Court for the District of Columbia, asking a judge to certify that all male claimants who have been denied access because they were an African American male by the claims administrator in Portland, Oregon, EPID, EPIQ. EPID has denied virtually every claim that was filed by an African American male or by an African American female who was filing that claim on behalf of her brother or father or some other African American male. We believe, and our attorneys are arguing, that denial, based nothing upon their race, is a gross violation of the Civil Rights Act of 1964 as amended, and particularly Title VI of that act. We celebrated several months ago in Selma, Alabama, where African American males and females were beaten, as it were, because they were denied the right to vote. And subsequently, Congress passed the Voting Rights Act of 1965. However, a year before that, Dr. Martin Luther King and others, particularly President then Lyndon B. Johnson, passed an act known as the Civil Rights Act of 1964, and particularly one of its subcomponents, Title VI. If you might, allow me then to read at least some of the basic language of the Civil Rights Act of 1964 and Title VI. And it reads in part, it says, prohibition against exclusion from participation in, denial of benefits of, and discrimination under federally assisted programs on grounds of race, color, or national origin. It states as follows: no person in the United States shall, on the grounds of race, color, or national origin, be excluded from participating in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal assistance or financial assistance. Our attorneys are arguing that what the claims administrator and USDA are doing by denying African Americans male violates this provision, this guarantee of rights. In other words, what it means in essence is, if you are a contractor, if you are receiving money from the federal government or any of its agencies, the Labor Department, the Department of Education, the Department of Defense, and you deny or you allow that subcontractor to discriminate against a person because of their race, color, or national origin, you then, the recipient, the subcontractor, have violated this provision. And we believe that that violation is actionable. As I said, on today, our attorneys, June 9th, 2015, our attorneys have filed a complaint and asking that the federal court first and foremost certify that all African American claimants who have been denied by the Claims Administration in Portland, Oregon, EPIQ, EPID, or the old Pullman Douglas Corporation, that they should be sued and enjoined from receiving any dollars from the United States Department of Agriculture, which is a federal agency. And our attorneys are asking for what we call damages and a jury trial. And those damages we are asking for would be an amount to, or the amount of, $1.8 billion. So here again, we want to leave you with two things. What we are doing with respect to our current members who are not current by June 8th, and non-members who want to become members of this association who were late That is to say, they made the attempt to become members after June the 8th. We're going to allow, we've had several discussions with our legal representatives, we're going to allow those individuals in because of the history, the similarity of situations that happened in Pigfoot 1 and subsequently became in Reed Black Farmers discrimination litigation. If you remember, a lot of folk got denied who were trying to get paid in Reed Black Farmers discrimination litigation because they were not members, or they were not, shall we say, certified under the 5G paragraph of the consent decree. 5G said you must have attempted after, or 5G said basically for those who attempted after October the 12th of 1999 would not be allowed. The attorneys told them that they would not be allowed. But we see that Congress came on board several years later and allowed those individuals only. Those meanings the ones who tried to get in. And this is one of the reasons now we have filed this Rule 24, because we have a lot of African Americans who couldn't or were not allowed in Pigfoot 1, couldn't get into Pigfoot 2 because they didn't try, and now there's no other lawsuit out there for them. So it makes sense then that this Rule 24 motion that has been filed by BIFA would be the only opportunity for those individuals to seek redress and relief for the years of discrimination at the hands of USD employees through any of these lawsuits. The second decision that we have made reference to is the fact that we have filed a complaint in the federal district court, the District of Columbia, that is to say the federal courts in Washington, D.C., where all of these lawsuits have already been adjudicated, on the basis that what the claims administrator is doing in Portland, Oregon, with respect to denying black males the opportunity to participate in the Hispanic and female farmers and ranchers claims process or framework is a violation of, at a minimum, the Civil Rights Act of 1964 under Title VI, and perhaps, we believe, other federal statutes as well. And that we are hoping that, here again, that you will be able to use this video, and feel free to call our office, which is at 901-522-8880. And if you have any questions regarding the contents of the material that has been discussed in this video. Thank you, and God bless.